name is Kevin Hunter. I'm the Marketing and Business Development Manager here at Doyle Clayton. Today, I'm joined by Zahira Patel, who's an associate in our business immigration team, and also Liz Kiniston, who's a senior associate specializing in business immigration and employment. Good afternoon, both. How are you?
Good afternoon. Good, thank you.
Thanks.
Good. So today we're kind of discussing employment and sponsorship implications, a sponsored employee who is at risk of redundancy. Sounds like an interesting topic. Why do we feel it's important at this moment in time?
Well, I mean, given the kind of economic climate at the moment, we are noticing a lot of our clients having to kind of make people redundant, or a lot of kind of employees contacting us who are at risk of redundancy. As you can imagine, they're kind of many of them have very similar questions that they're very concerned about, particularly if they're on a sponsored work visa. They're kind of worried about things like how long they have before they need to, say, file a new application, what they need to do. So we thought it would be quite helpful to summarize really the main things they need to kind of think about if they find themselves in that situation.
Yeah, exactly.
Okay. So I think we'll probably start with the main process. So what usually happens in a redundancy situation? What's the normal kind of go-to process?
Yeah, so as you say, I think it's helpful to get an idea of what would usually happen in a redundancy situation before going into the detail about what individuals can do. So a company might decide that it needs to make redundancies to reduce staff numbers in certain situations. So, for example, if there's a downturn in work, or perhaps if it moves part of the business abroad, or maybe if there's an internal restructure and they reallocate work to different roles. And so if a company decides to make redundancies or is considering making redundancies, then it would normally take a number of steps. So first of all, the company will need to decide which roles are at risk of redundancies. And that normally means identifying a pool or group of employees that are at risk of redundancy. So to take a simple example, if there was a team of, say, 8 sales managers, and the company knows they might have to make 4 of those people redundant, leaving only 4 roles, all 8 sales managers would usually be pooled and put at risk of redundancy. And then as part of the redundancy process, all 8 employees would usually be assessed against subjective criteria, and the employees with the highest scores would usually be offered the 4 roles that are left. Really important to bear in mind that sponsored workers should be assessed as part of this process in exactly the same way as non-sponsored workers. So they shouldn't be treated more or less favourably when sort of being assessed. The company should also follow a consultation process, which generally means they should meet with each employee that's at risk of redundancy individually to explain the reasons for the potential redundancies, to answer any questions that the individual might have, and to consider any proposals that they have for avoiding redundancy. And it's really important to note that the redundancy should be a proposal only when this consultation process is going on. So the employer shouldn't have reached any definite decisions and should enter into the consultation process with an open mind. Also, just to mention that if an employer plans to make 20 or more employees in one establishment redundant within a 90-day period, the employer also needs to carry out what's called collective consultation. So as well as consulting with the employees individually, they'll also need to consult with employee representatives or trade union representatives about proposals. Finally, the company should think about whether there are any suitable alternative roles for employees who are at risk of redundancy. Certain employees, so for example, those on maternity leave, are entitled to be offered suitable alternative roles in preference to other employees. Now, if you're a sponsored worker who's at risk of redundancy and your employer offers you another role, you understandably may be keen to accept the role to protect your immigration position. Just worth bearing in mind that if your new role is in a different occupation code or job type to your current sponsored role, so for example, perhaps if you were a sales manager and you were offered a role as a project manager, then your employer would need to assign a new certificate of sponsorship to you, and you would then need to make a new work visa application, and you'd need to wait for that new application to be successful and your new work visa granted before you moved over to that new role. On the other hand, if your new role is in the same occupation code as your current role, you don't need to apply for a new visa. Instead, your employer just needs to report to the Home Office any changes to your role. So, for example, a change to your job title, core duties, or perhaps if your work location changes or your salary reduces, and they may need to, so they do need to make that report within 10 working days of the change taking place. And that's really just, we're mentioning it for completeness, so your employer would be in charge of that part of the process and would tell you if you needed to apply for a new visa.
That's obviously a lot of steps and a lot of information there. As an employee, if you're going through this process, am I right in thinking, well, I hope so, that employers should be communicating all of that to you, as in what their obligations are and ensuring they're being met? Yeah,
absolutely. Yeah, the company should tell you that they're carrying out this process, and they should be sort of having meetings with you and explaining what's going on throughout the process. Yeah.
Obviously, there's a lot of comprehensive steps, details there to take. I imagine it's a difficult period for any employee going through that, but for a sponsored worker, there must be that additional fear of where your status stands in terms of your right to work in the country. So if a sponsored worker is made redundant, what are the next steps?
Yeah, so if a company decides to make any employee redundant, so whether they're sponsored or not, they should notify the employee in writing and also confirm their termination date. The employee may also be entitled to receive a statutory redundancy payment based on their age, salary, and length of service at the company. And you can check online, the government website's got a calculator that you can use to see how much you'd be entitled to. Usually an individual will only qualify for a statutory redundancy payment if they've been employed by the company for 2 years or more. When deciding on an employee's termination date in a redundancy situation, an employer's got different options they can take. So let's assume that the employee's got a 4-week notice period. So option 1 is the employer can require the employee to work their full 4-week notice period. So perhaps keep coming into the office, certainly continue to perform their duties and do any handover throughout that 4-week period. Option 2 is that the employer can put the employee on garden leave for their notice period. So the employee would remain employed throughout their 4-week notice period, but wouldn't be required to do any work. They could be at home and would just need to be available for any questions that their employer might have during that period. Option 3 is that the employer can terminate the employee's employment immediately and make what's called a payment in lieu of their notice period. So the employee's employment would terminate immediately, and they would receive a lump sum payment of 4 weeks' salary to compensate them for their notice pay. Yeah. And sometimes an employer will do a combination of those options. So, for example, again, if the person's got a 4-week notice period, the employer might put them on garden leave for 2 weeks and then terminate their employment and make a payment in lieu of the remaining 2 weeks of their notice pay. Now, obviously, for sponsored workers, it's often better if their employer goes for option 1 or option 2. So either makes them work their notice period or puts them on garden leave for their notice period, because that will delay their termination date and will give them a bit longer to apply for a new job and then apply for a visa. And Tahira is going to talk a bit more about applying for a new visa later. If a company makes a sponsored worker redundant, they need to report that to the UK Home Office, and they need to make that report no more than 10 working days after the employee's termination date. Once the company has submitted that report to the UK Home Office, the Home Office is on notice that the employee is no longer sponsored by the business, and they should then issue the employee with a curtailment notice, giving them 60 days or until the expiry date of their visa if sooner to apply for a new visa or leave the UK. And if the employee's got any dependent family members who are on their visa, that their permission to stay will also be curtailed. And again, Tahira is going to talk a bit more about this later. Just one extra point to mention is that a sponsored workers immigration permission is tied to their current sponsor. So that means that they can't work for another employer or work on a self-employed basis or as a freelancer until they've obtained their new visa that allows them to do that.
So obviously in a sponsored work, there's a lot more considerations to take into account, especially in terms of their working status. So with that in mind, what practical steps can a sponsored worker take if their role is at risk of redundancy?
Yeah, so a really good question. So if you're a sponsored worker and you're told to say that you're at risk of redundancy, there are certain steps that you can take. So first of all, it's worth just thinking about whether there are any immigration documents on your work computer or your work emails that you might need in the future. So for example, you might have saved a copy of your submitted visa application form or your certificate of sponsorship on your work emails and not have a copy on your personal computer. If that's the case, then you might want to obtain copies of those documents just in case you need them in the future. Before you do that, it's worth just checking that with HR. But yeah, then it is a good idea just to have those documents in case you need them. Another thing you can do is if you use your work email address or your work mobile phone to set up your online Home Office account, which you might have done if you were using the new online only application process and verified your identity using the Home Office app, then you need to update your contact details on that account as soon as possible, just to make sure that you can continue to access your account after you leave the company. And third, and this is, I think, sometimes something that people sort of don't think about when they're leaving, but often employers will ask sponsored workers to sign a letter agreeing to repay some of the visa application fees that were paid when they applied for their visa if they leave the company within a certain time period. So it's always worth checking whether you signed one of those letters, and if so, whether you are required to repay any of your visa fees if you're made redundant. So often a company won't require you to repay the fees if you're made redundant, but if your letter isn't clear or it suggests that you may need to repay the fees, it's definitely worth just checking with HR as soon as possible to confirm the position.
So with that in mind, I can just imagine the stress of the situation where the sponsored workers potentially be going through that process. What can a sponsored worker do to protect their immigration permission?
Yeah, so that there are some things that you can do, particularly if you are offered a settlement agreement, and it's fairly usual for employers who are making employees redundant to offer them a settlement agreement before they leave. So if an employee signs a settlement agreement, they will, among other things, be agreeing not to bring any employment law claims against their company, and in exchange, the company will usually give them a financial sum that's a bit more than any statutory redundancy payment that they're entitled to. The employee will need to take legal advice before they sign the settlement agreement, and often the employer will contribute a bit of money towards the legal fees that the employee will pay to get the advice. So if you're a sponsored worker who's offered a settlement agreement, you can ask your employer to agree to certain things in the settlement agreement to help protect your immigration position. If your employment lawyer who's advising on a settlement agreement also specialises in immigration law or has colleagues who specialise in immigration law, then they should be able to help guide you through the process and suggest things that you might want to ask for. But things that you could ask for in your settlement agreement include, as I mentioned before, your employer will need to report to the Home Office within 10 working days that you've left the company. You could perhaps ask your employer to agree that they will only submit that report on the 10th working day after you leave the business. And that should slightly delay the day that you get that curtailment notice that I mentioned before, giving you 60 days to leave the UK or apply for a new visa. So it'll give you slightly longer. Your employer might tell you that they are going to terminate your employment immediately and will make a payment in lieu of your notice period. You could perhaps ask them if they're willing to instead let you work your notice period, whether that's actively working or going on garden leave. And that will obviously delay your termination date, which will give you a bit longer to find a new job and apply for a new visa. Similarly, if you have any accrued holiday that you haven't used, you could ask if the company is willing to let you take that at the end of your employment to, again, delay your termination date and give you a bit longer to apply for a new visa. If you do ask for your termination date to be delayed in this way, it might be worth asking also for something to be put in the settlement agreement saying that you are allowed to, or you may ask to bring forward your termination date So you might want to do that if, for example, you've been offered a new job and you want to start the new job as soon as possible. So you can include something in the settlement agreement saying that you may ask, as I say, for your termination date to be brought forward, and that your employer won't unreasonably refuse that request. In terms of asking your employer to delay your termination date in this way, like say putting you on garden leave or allowing you to work your notice period, employers might not be willing to agree to this. Sometimes if they're doing, say, a big redundancy exercise, they're making quite a few people redundant, they can sometimes be a bit unwilling to have some employees leaving on, one date and sponsored workers leaving on a later date. But it's worth asking. Often employers are sympathetic to a sponsored worker situation. They do recognise that it can be really difficult if your visa is tied to your employment status. And so it is worth asking, because sometimes they're willing to be a bit flexible and allow you to work a bit longer. If you're entering into discussions about your settlement agreement, you could also ask your employer if they're willing to agree that you don't need to repay any of the immigration fees paid for your application. So that's sometimes worth asking for if those are payable. And the last thing you can ask for is you could ask your company to contribute to your legal fees for taking advice on your immigration situation. And alternatively, it's fairly common for employers to offer to let you contact their immigration advisors for advice. So that's certainly something that may be offered to you, or that you can ask the company if you can do that.
One question I have, in terms of an experience going through the process, I suspect there are legal obligations, and those are the obligations, and actually whether the employer handles it in a nice way or not so nice way, that's down to the individual experience. And it's just unfortunate if somebody's not really been managing it in the best way, and as you say, empathizing with your situation. So I presume there can be cases where those requests you gave examples of, and the employer can just say no, and you can find yourself in the most difficult situation. But as long as the laws followed correctly, then is that just unfortunate?
Yeah, I think unfortunately that is the case. I think sponsored workers, unfortunately, in this situation, aren't entitled to extra protections, even though, of course, being made redundant sort of has an extra implication for them, that their visa is linked to their employment status. And yes, I think it's very much a matter for the employers. Some employers, as I say, can be flexible and can be willing, particularly if somebody's sort of, very valued and they've been with the company for a long time. Often you will see that a company is prepared to delay their termination date just to give them a bit longer, or say give them access to their immigration advisors to help them out. But yeah, there's no obligation for them to do that. So it's sort of a matter of goodwill, I guess, for the company as to whether they're willing to do that.
Okay, so leading on from that, I suppose as a sponsored worker, Zara, when you are made redundant or you're going through this process, the immediate question that comes to your mind is, what happens to my UK sponsored visa?
Right, and it's a great question, one we get all the time, because as you said, that's kind of the immediate thing on people's mind if they are a sponsored worker. So, Liz has covered some of the employment law issues, but for the purposes of just the sponsorship itself, the most important thing that someone in this situation needs to bear in mind is that their visa isn't cancelled immediately. So yes, it's true that a sponsored worker's visa is very much tied to their employment, but that doesn't mean that the day that their employment ends is the same day that their visa ends. Instead, what happens, and Liz has mentioned it, but it is worth repeating just because it is important, because it means people have more time than they think. So what happens is, once your termination date is decided, your employer files the termination notice to the Home Office kind of within 10 working days of your last day. So if you have a 3-month notice period and you're going to work all of those 3 months, then that notification won't go until 10 working days after those 3 months. But then when the Home Office receive that notification, they will send you a curtailment letter, which is your letter saying that your visa will be cancelled, but they'll give you 60 days usually in that curtailment letter, or less if your visa was going to expire before that 60-day period, kind of whichever is shorter. So the most important thing to do is to wait for that curtailment letter and see exactly when your visa will terminate. But as I said, it's it's usually a bit longer than people normally think. Now, within that 60-day period, the most important thing that you need to know if you find yourself in this situation is you have until the end of that curtailment period to either file your new UK visa application online, make a valid application, or to leave the UK. Now, you shouldn't leave the UK within the period when, during this curtailment period, or even once you filed a new visa application. So you shouldn't leave the UK because you might have problems re-entering, but you don't actually need to depart the country until the end period of your curtailment. So that is potentially good news in that normally people do think they have less time than that. Another kind of helpful thing is that during that curtailment period, I've mentioned you need to either file your new application or to leave the UK. Now, the good thing is that requirement is just to actually file it. It's to file it online. You don't actually need to have your new visa before the end of your curtailment period. So say your curtailment date is 30th of May, even if you file an application, a valid one, online on the 28th of May, you're still fine even if you don't get the visa decision back within the next 2 days. But you shouldn't leave the UK until you do get your new visa. So I think that's probably the most important thing to bear in mind.
Obviously, there's a number of different scenarios when going through that redundancy process. One of them being if you receive an offer from another employer. So what are the visa options in regards to that situation?
Yeah, so that's a good question, and they really depend on the kind of role and on the status of your new employer. So if you are already a sponsored worker, I guess an initial visa option to consider is whether your new employment offer could also fall within the sponsored worker category. Now, there are various sponsored worker categories, but probably the easiest one to file from within the UK would be a skilled worker application. So if you already are a skilled worker, you should kind of first look at whether your new employer can support a new skilled worker visa application. I won't really go too much into the other sponsored worker visas. So, for example, the global business mobility routes, just because the requirements for that category are a bit more difficult to fill for someone who's currently already in the UK and being made redundant. But if you do find yourself with an offer from an employer who can potentially offer you kind of a skilled worker, a role that is suitable for skilled worker sponsorship, the first thing to really bear in mind is, do they already have a sponsor license? That is going to be important because it will kind of determine how long the process will take for you to get your new visa and be able to kind of firstly file your new application in time, but also to get your new visa and start working. So you kind of have two things to think about. One is, as I said, is your role actually going to be sponsorable under the skilled worker route? So this will be things that you might already be familiar with that you had to kind of prove when you got your current visa. So, is your role skilled, your potential new role skilled to A-level or above? If it's just under the skilled worker route, is the salary requirement met? All of those things. But also do check if they already have a sponsor license, as I said, because that will determine the lead time. So
in relation to that, what's involved in an application for a new role with an existing sponsor license holder? Is it different to if they didn't have one?
Yeah, so it's different in that if they didn't have one, they would first need to apply for a sponsor license. So it's good if they already have a sponsor license because it means you can start the kind of visa process straight away, once you've accepted the job offer. The way that this works, and you might already be kind of familiar with it if it's someone who, for example, was already on a sponsored work visa, some parts of it will be quite similar to the process that they may have followed in the past. But the first step is that the new employer, if they already have a sponsor license, can assign what is called a certificate of sponsorship. So that's kind of like your UK work permit that allows you to carry out that role in the UK once you get your visa. As I said, as kind of part of that assessment, the new sponsor will be checking whether or not that role that they're offering you is eligible for the requirements of that route. So this is when they might check, things like salary eligibility. They may ask you for things like passport copies, your visa history, how you previously satisfied the English language requirements. So there'll probably be a lot of back and forth with either the employer or the employer's kind of immigration advisors. But once everyone is kind of satisfied that all of the requirements are met, the sponsor will assign you your certificate of sponsorship. And from there, really, you can go and file your application online. And as I said earlier, it's filing the application online that's important within your curtailment period. So that's really the important thing. Now, the good news is for most people who are in the UK now on a skilled worker visa, if they have a skilled worker BRP, which is a kind of a biometric residence permit, they can actually apply for their new skilled worker visa completely online, completely digitally, without having to go to a biometric appointment centre, which is very useful because it cuts down the kind of lead time for this entire process. The way that works is they can use the Home Office kind of ID check app, which is a way for them to digitally verify their identity. So kind of take a digital biometric photo and, etc. The kind of app should read the data from their existing BRP. For individuals that can do that, the good news is that they can then file the rest of their application, including all of their supporting documents, entirely digitally. And that means the processing time for that application will start from the date that they upload everything digitally online. Unfortunately, there are problems with the app being able to read all BRPs, or if they are applying for kind of a route which doesn't have that function at the moment to use the Home Office app, then they'll need to attend a biometric appointment centre, which adds additional time to the process because they'll need to kind of wait for the appointment. Usually it's about a 1 or 2 week wait for the appointment from the date that they submit the application online. So when they're kind of thinking about timeframes within that 60-day period, they still only need to file the application online within that 60-day period, but for them to actually then start work, the actual processing time for the application won't start until they attend their biometric appointment. In terms of processing times, it's 8 weeks via the standard process. But if the new employer wants them to start the role earlier, or if they themselves want to start the role earlier, just because they want to obviously kind of be working again, then what they can do is purchase priority service for an additional fee, and that will expedite the process to 5 working days from the date either on which they submitted their documents digitally or the date on which they attended the biometric centre, kind of depending on which route they took.
So the options available in terms of managing time, managing the process.
Yes, so for the skilled worker route, yeah, you can, at the moment, priority services are available. There are rare instances in which they are pulled. So for example, during the pandemic, they kind of suspended all priority services, but at the moment, priority services have kind of good availability for the skilled worker route. So that is always an option, and it's always worth checking if the new employer would potentially support priority service and pay for it.
Imagine that's always an option one would consider, just for the peace of mind.
Yeah, as I said, even though you don't actually need the decision, you just need to file the application online and before the end of the curtailment period. Obviously, for most people, that is still stressful, at least just to not have a decision and to not be able to kind of work in that time for a new employer or a new role. So yeah, for both the peace of mind and just the practicalities of being able to kind of change roles, it's always worth at least checking if you can apply for priority service. The kind of, it expedites it quite a lot. As I said, 8 weeks standard, 5 working days priority. Yeah. Most people prefer the kind of latter. It's a big drop in lead time.
Yeah, I'm just trying to imagine, place myself in that situation. I think I'll just, for peace of mind, go for the quickest option possible.
Yeah.
So that's the implications with an employer that has a license. What about an employer that doesn't have a license?
Yeah, good question. And this is why, I said that's one of the first things to check, because really the main thing will be you'll have to do everything that I just said. But before you can do that, your new sponsor, your new employer will need to actually apply for a sponsor license, have it in place, and have the certificate of sponsorship actually available to assign to you before you can start that whole process that I've just described. So it adds on, quite a significant process before the visa application process. Now, applying for a sponsor license is, it can be a lengthy process. So from the date that an employer files a sponsor license application, it could take 8 to 10 weeks for it to be processed and approved. It could be longer if the Home Office decide to kind of make a pre-license visit or a check, or if there's kind of questions or anything like that. So that might eat quite a long way into that 60-day period. Now, that's from the date that an employer files their sponsor license application online. But remember, before they do that, that employer themselves will need to kind of submit an application form and submit all of the supporting documents. And so really how long the whole process takes will just depend on how long it takes the employer to kind of gather all of the documents that they need. You know, and those can vary by kind of how long the company has been operating. So there might be more documents to submit or additional things to think about if they've been trading for less than 18 months or if they're in specific industries. And as well as kind of general documents that usually have to be submitted. So, you know, they might need to kind of gather things like bank statements, HMRC documents, VAT documents, and it just varies so much in terms of how long a company will take to do that, because some companies might need to check things with their accountants and wait for documents from, you know, from them. So it's always worth kind of checking in with them if you are offered a role with a new employer, just kind of how long they anticipate it taking for them to kind of gather the necessary documents that they need before they even file an application. As I said, when they then file the application, the standard processing time is 8 to 10 weeks. Now, again, a priority service may be available to expedite that, but unlike the visa application priority fee, for the sponsor license, the Home Office actually restricts the number of priority slots that are available every day. So it's actually quite hard, especially at the moment, to get one of those slots. That your employer will kind of need to keep making a request to even be able to make the payment to do that. So, you know, it's hit and miss. Your sponsor may get priority service and be able to kind of have the sponsor license in place earlier, but if not, that you might have to wait a full kind of 8 to 10 weeks before they can even get the sponsor license in place. Now, once they get a sponsor license in place, then they can proceed with all of the same steps that we've just talked about. But one thing they should just check is that as part of that sponsor license approval, the sponsor was actually granted a certificate of sponsorship allocation. Because if for some reason the sponsor license was approved, but they didn't receive one of those, then the sponsor will need to first apply for that. So there are a few different moving parts, and it's just always good to keep checking in with the employer and sort of seeing where they are and how long they expect all of this to take.
So as the employee, lots of factors to consider.
Exactly.
Especially when looking at the next steps. And I suppose even when selecting an employer.
Yeah.
And it kind of feels like to me that maybe in some situations that the priority is the status of the employer rather than what job is maybe the better one.
Yeah, so actually I've had you know, it really depends on the person. I have definitely had clients who, you know, really have been offered a role that is their dream role and, you know, kind of the perfect role. And in that situation, they want to wait for that new potential employer to get a sponsor license, even though if they went with another employer who already has a sponsor license, you know, obviously they could submit that application much more quickly. But, you know, for people who are, you know, if your main priority is going to be protecting your immigration status and filing your application as soon as possible, or even just kind of working as soon as possible in the new role, then yeah, you know, whether or not an employer already has a sponsor license or not is going to be kind of probably one of the most important considerations.
So once they've worked their way through all of that, in terms there's, you know, for some permanent residency might be an option, I believe. Can that still apply at the end of the original 5 years?
Yes, that's correct. Just to be clear, the 5-year period that you've mentioned for permanent residence is for the skilled worker route. The other route that I've been talking about, the global business mobility senior or specialist worker route, actually doesn't allow for settlement after 5 years. But under the skilled worker route, you can potentially apply for settlement in the UK after 5 continuous years of residence in the UK as a skilled worker, provided that you meet all of the requirements at the time. The good news is that under the skilled worker route, a break in your employment is absolutely fine as long as your skilled worker permission remains valid throughout the entire 5 years. And the way that you keep your skilled worker permission valid is by filing your new visa application in time within the timeframes that I've mentioned. So that's really good news. Now, obviously, when you come to the end of your 5-year period, you must also make sure you meet all of the other usual skilled worker requirements at the time you file the application. So, for example, You'll need to meet the absence threshold of no more than 180 days of absence from the UK in any rolling 12-month period. You'll need to show that your role is still needed in the UK for the foreseeable future. You'll need to make sure you meet minimum skill and salary thresholds, things like that. But as long as you meet the requirements and your skilled worker permission has remained valid throughout the 5 years, the break in employment won't impact you being able to apply for settlement. So that's good news.
That's I imagine that comes at some relief for many, because I think they long-term implications as well as the short-term must be a concern for them.
Exactly.
So looking at the immediate impact, when does it become possible to start working for a new employer?
No, that's a really good question. So as I said, as skilled workers or delivering mobility routes, any sponsored worker really is tied to their employer. Now, although you can remain in the UK when you file a new application, you can't start working for your new employer until you've received your new visa approval and the new employer has carried out what's called a right to work check. Employers are required to carry out right to work checks for all new hires in the UK. Now, the way that these right to work checks are carried out differ slightly depending on whether you submitted via that online only process that I talked to you about earlier, the one using the Home Office ID Check app, or whether you applied via the biometric appointment route. Now, for someone who applied via the online only route, the good news is as soon as you get your Home Office approval email, so this is when your new visa application has been approved and you'll receive an email confirming that, what you should be able to do is you should be able to log into your online account, which you will have had to set up to submit your online application, and you'll be able to generate what's called a share code. It's a code that you can share with your new employer, and that will then allow the new employer to carry out the new right to work check. So as long as that is done correctly, the new employer can verify your new right to work check on the basis of your new visa. As soon as that check is done, you can start your new role. For individuals who applied via the biometric appointment route, unfortunately, they won't have an online account to generate that share code. So what they'll need to do is they'll receive first the Home Office kind of approval email, but then secondary to that, they'll also receive a new biometric residence permit or BRP. For now, the Home Office are phasing them out kind of in 2025, but in the immediate term, they're still kind of going to be issued for some individuals. And so for individuals who applied via the biometric appointment route, it's only when they get their new BRP card that they can generate that share code that allows an employer to carry out their right to work check. So again, in that instance, once they've got the new BRP, once they do the right to work check, then they can start the new role with their new employer.
Okay. So looking at worst case scenario potentially, what happens if they can't find another job suitable for sponsorship?
So that's a really good question, because as I said, within that curtailment period, what you need to do is either file a new valid application from within the UK, or you need to leave the UK. So to avoid the worst possible scenario of you having to kind of leave the UK by your curtailment date, if you can't find a role that's eligible for sponsorship in the UK, then instead what you can do is consider whether you can apply for any alternative personal immigration categories or non-sponsored routes. So these will be things like, whether you can apply for youth mobility scheme visas, ancestry visas, kind of global talent visas, a relationship-based visa if you, for example, are married or in a relationship to someone who is British, for example. Now, the slightly complicated thing is for each of these routes, they will have their own rules about whether you can switch into them and about whether you can kind of maintain the time that you've already spent in the UK for future purposes of settlement. So, it might be that you can switch to another route, but you'll lose the time you've already accrued in the UK for the purposes of that kind of 5 years to settlement that I mentioned before, if you are currently here as a skilled worker, and in which case, what you need to kind of consider is, is it more important that you kind of can stay in the UK and switch to another route and start accruing time on that route, or, if kind of the settlement was really the most important thing for you. Now, there are a lot of, potential of these non-sponsored routes, so I probably can't cover all of them right now, but my colleague Adam, who is a senior associate at Door Clayton, he actually specialises in personal immigration routes, so he can take you kind of through a brief overview of the types of routes that individuals can consider if they can't find another role that is suitable for sponsorship.
There is a lot of information that we've covered there, lots of possible route scenarios and and different options available for the individual. And it sounds like nothing can ever be one size fits all. It's dependent on the individual circumstances, situation, whether it be even their own personal living situation in terms of what they want to achieve and what's best objectives for them and their family. If it strikes me that an individual potentially may not know what is available to them. So the thing that comes to my mind, the immediate call to action there is that actually you should go to advice when needed, seek advice from your advisor to see what your options are.
Yeah, absolutely. And sometimes your kind of current sponsor who's considering making you redundant, or even your new potential sponsor may actually have either immigration or employment lawyer, or both, who they actually contract out to assist you. So it's always worth asking in the first instance whether either your kind of current employer or your new employer can facilitate some of that legal advice for you. But I would say, it's always worth taking that advice if possible. Absolutely.
And I think it's really important just to help you sort of plan for the future, if nothing else, just because, as Zahira said, different, it might be that there's another visa category that you can move into that's available to you and might work for your personal situation. And so it's important to know all of the options that are available to you. And also, I think, to understand, and I think every so often we see people come to us who perhaps haven't appreciated that once they leave one job, they can't sort of work on a self-employed basis, they can't set up their own business. And that actually, if they do, say they do it for 6 months and then move to another employer, that can actually have implications for their future settlement application. So I think it's really important to take legal advice, just to understand all of your options, and from the employment perspective, obviously, to understand whether your employer's followed a fair process and any avenues that might be open to you from that perspective.
Right, so as we sum up here, and so in addition to seeking legal advice and making sure all the options are available to you, we'll go from one from each. What do you feel are the key takeaways from this, from what we discussed today? What are the key messages for any sponsored worker who is thinking they may be facing this unfortunate situation? What do you feel are the key takeaways from what we've discussed today?
So I think from the employment side of things, I think it's important, if you're put at risk of redundancy, it's important to start conversations with HR as soon as possible about your visa situation, to understand what whether the company plans to, if you are made redundant, whether they're going to ask you to work your notice period or you will terminate your employment immediately, just again, because that can help you plan, understand your timeframes. And I think also to see if they might have be able to refer you to immigration advisors. But I think it's also just being aware that if you're offering a settlement agreement in particular, you can try and negotiate to make your position just a bit safer and to protect yourself.
And from the sponsorship perspective, I think the most important thing to remember is going to be that 60-day curtailment period that you have. So the most important thing is to know when your sponsor is going to and has made the report to the Home Office, notifying them of the last date of your employment, knowing what email address and address was used as part of that notification, because that will be the kind of the email address the Home Office used to contact you. So most often they contact you by email, sometimes by post. And then looking out for that curtailment letter and actually looking at the date. And that will be the date. The most important thing is that you either need to file a valid new application by, or the date by which you need to leave the UK. So really that gives you the time frame in which you need to kind of plan all of these other steps that I've just mentioned.
Perfect. Well, thank you very much for your time both. As ever, if anybody listening feels that they need support with topic in relation to what we've discussed today, contact our business immigration team. Get details on our website www.doorclayton.co.uk. But for now, thank you very much. Appreciate your time.
Thank you.
Thanks.